At precisely 9:33 Eastern Standard Time this morning, a digital notification arrived at my office that fundamentally altered the trajectory of the government case against Ivanka Trump. It was a formal message from the legal team representing the former First Lady, Melania Trump. The message was stark, final, and disastrous for the defense. The cooperation deal was dead. This wasn't just a standard email. It was the refusal of a lifeline. The proposed agreement had been carefully crafted to trade Melania's testimony for a significant reduction in Ivanka Trump's potential prison sentence regarding the federal fraud charges she currently faces. Melania simply refused, but the silence from her legal team was quickly followed by a chaotic noise from elsewhere. Exactly 17 minutes after that refusal landed on our servers, a new stream of evidence started to flood in. We got a voluntary witness statement from a Secret Service agent, a cache of timestamped text messages, and screenshots of a social media post that was deleted almost as fast as it was written. Together, these papers paint a terrifying picture of what happened inside the defendant's inner circle the moment his attorneys broke the news that his wife would not intervene to save his daughter from federal prison. Before you write this off as just another story in a tabloid family feud, you need to understand the gravity of the legal mechanics at play here. This is not a personal dispute. This is a federal case with liberty at stake. Prosecutors put a standard yet powerful deal on the table. If Melania testified about 3 specific financial transactions she personally witnessed, the government would suggest leniency for Ivanka. It was an exchange of information for freedom. Melania rejected the trade. The effects are mathematical and brutal. Ivanka Trump is currently looking down a sentence of 11 to 19 years in a federal penitentiary on charges of bank fraud. Had her stepmother decided to take the stand and corroborate the facts, that window could have been compressed down to 6 to 10 years. To put that in human terms, we are talking about the difference between Ivanka's youngest child finishing elementary school while her mother is behind bars versus that same child completing high school before her mother walks free. That is the timeline Melania chose not to change. And the response from the head of the family based on the intelligence my office secured this morning was nuclear. We have gotten documented proof of explosive rage, intimidation attempts, and behavior that prosecutors classify as consciousness of guilt. I am going to walk you through every piece of this. We will reconstruct the timeline of how Melania and Ivanka became key figures in this investigation. We will dissect the 3 specific financial events Melania observed. We will analyze the evidence of the defendant's violent reaction this morning, break down the brutal prison calculus facing Ivanka, and reveal the larger pattern. Because Ivanka is now the 3rd member of this dynasty to be charged in these interconnected financial schemes, we are watching this case in real time. This is about raw data, not political spin. If you want to understand the machinery of this trial without the distortion of TV news, you need to be plugged into the source. For those of you who need to see the source documents before the rest of the world catches up, I have opened a private channel. This is where I am dropping the unfiltered updates, the raw timestamps, and the behind-the-scenes details that don't make it into the final movie cut. It's a straight line for breaking news that often hits hours before the mainstream media runs with it. I've pinned the invitation to the WhatsApp group in the description below. It's the only place to get the unredacted reality of this story as it unfolds. Now let's go back to the beginning. We need to build the timeline to understand why today's refusal was the final nail in the coffin. It started on April 15, 2024. That was the day I approved the initial subpoena for Melania Trump's personal financial records regarding specific transactions within the Trump organization. This wasn't a fishing trip. Her name was inked on the bank papers. She was named as a formal signatory on accounts that were directly tied to loan applications we now know were fraudulent. Her signature was the thread that unraveled a tapestry of 17 unique transactions occurring between 2018 and 2022. Fast forward to July 2024. By this point, my office had brought Melania in for questioning twice under the power of a subpoena. It is crucial to understand her status at this time. She was not a target of the probe. She was classed as a witness. We knew she possessed direct personal knowledge of the financial interplay between the defendant and his daughter. During these proffer sessions, basically off-the-record interviews used to gauge the value of a witness, something massive was revealed. Melania admitted she was physically present in the room during meetings where the defendant explicitly told Ivanka to falsify loan documentation. She wasn't just in the room, she was at the table. She heard the orders, she watched the papers being doctored. Then came October 3, 2024. This was the day the hammer dropped. I officially charged Ivanka Trump with 3 counts of bank fraud, 2 counts of tax fraud, and 1 count of criminal conspiracy. The evidentiary reason for these charges was overwhelming, but any prosecutor will tell you that a cooperating insider makes a case bulletproof. I knew Melania was the key to locking this down. On December 9th, 2024, my office made the move. We sent an official proffer letter to Melania's legal counsel. The terms were clear and rigid. If she agreed to testify truthfully regarding 3 specific financial events where she had firsthand visibility, I would officially suggest a downward departure, legal speak for a reduced sentence for Ivanka. Her team stopped. They asked an extension, then another. The January date dissolved. The February date evaporated. Her lawyers tried to hide behind the shield of marital privilege, claiming she couldn't testify against her husband. But that claim was legally hollow because marital privilege does not cover business transactions involving third parties. And that brings us to this morning, 9:33 a.m. The stalling ended. The refusal letter was brief, cold, and absolute. It stated simply that after careful thought, Mrs. Trump declines the government's offer of cooperation. She will not take the stand in United States versus Ivanka Trump. There was no reasoning given, no counter-negotiation, just a flat no. Let's clarify the legal truth here, because there is a lot of confusion about what a wife can and cannot be forced to say. Spousal privilege is meant to protect the sanctity of private marital whispers, conversations between a husband and wife about their personal lives. It is not a shield for corporate malfeasance performed in a boardroom filled with accountants and lawyers. Melania cannot be made to narrate what the defendant told her in their bedroom. But talks about Trump Organization asset valuations. That is business. Those are different rules. This refusal wasn't a legal requirement. It was a strategic move. Now, I need to show you exactly what she is hiding. We need to look at the 3 specific deals Melania could have illuminated, because the specificity is where the guilt lies. The setting was the senior offices at Mar-a-Lago. It was a high-stake meeting attended by the defendant, Ivanka Melania, and 2 accountants from the Trump Organization. The plan was a $47 million loan application to Deutsche Bank. I have the digital footprints, emails confirming the schedule, calendar invites, and testimony from one of the accountants stating the meeting took place. But what I am missing, what Melania took with her when she refused the deal, is the narrative of the talk. I need her account of the moment the defendant supposedly ordered Ivanka to inflate the asset valuations on that application. The accountant has already stated that the defendant told Ivanka to utilize property appraisals from 2017 to list values in 2019. Why? Because the 2017 numbers were significantly higher than the market truth of 2019. Melania was sitting right there at the meeting table. Her voice would have been the second source verifying the accountant's story, making it impossible for the defense to say the accountant was lying to save himself. We hold a chain of digital correspondence between Melania and Ivanka concerning an ear's audit of the Trump Organization's tax returns. It is a sequence of 15 exchanges where Ivanka appears to be panicking, asking Melania for advice on how to handle a problem with asset disclosure. Melania's answers are devastating. They imply a deep working understanding of offshore concealment. One message, which I will read to you verbatim, says, "Use the Cypress structure like we talked with your father. They can't trace beneficial ownership." The Cypress structure. I wanted Melania on the stand to explain that term. I wanted her to explain to a jury exactly what was talked with the defendant regarding that structure. I wanted her to explain what she knew about hiding ownership, because beneficial ownership concealment is the hallmark of sophisticated money laundering. We have unearthed bank records showing Melania Trump named as an authorized user on 3 specific foreign accounts, 2 in Cyprus and 1 in the Cayman Islands. These accounts were largely controlled by Ivanka. Between 2018 and 2022, a total of $18.4 million moved into these reservoirs. Melania's statement was the missing link to explain the origin of that cash. Was it income? Was it a loan? Was it stolen from the business? Her refusal leaves a gap in the narrative of purpose. In the courts, we call this corroboration. I already have the papers, the emails, the bank ledgers, the texts. I have the accountant. But when a family member who is physically present confirms what the paper says, it obliterates logical doubt. It blocks the exits. I successfully tried Paul Manafort for financial crimes. And in that case, his daughter's text messages were crucial. The dynamic was similar. Business crimes do not enjoy the security of family loyalty in the eyes of the law. Now, we must pivot to the response. This is where the case changes from a white-collar paper trial to something much darker. I need to show you the evidence of how the defendant acted when he realized his wife had gone rogue. This morning at 10:15 a.m., a member of the Secret Service assigned to the defendant's protected detail filed a voluntary witness statement with my office. This is a federal law enforcement officer breaking the code of silence because of what he experienced. The statement details a phone call intercepted by the agent's ears at roughly 9:52 a.m. The defendant was in his home at Mar-a-Lago. The agent, standing at his usual post just 12 feet away, heard the defendant screaming. The quote from the sworn statement says, "Melania is betraying this family. She is siding with Smith against her own daughter." The call went on for 4 minutes. The agent noticed that the volume and the profanity escalated with every second. When the line went dead, the defendant reportedly hurled his mobile device against the wall with enough force to shatter the screen. That is evidence item 1, a sworn report of rage from a federal officer. Evidence item 2, a text message conversation between the defendant and his son, Eric Trump. The timestamp is 11:03 a.m. this morning. The defendant wrote to Eric, "Make your mother understand what loyalty means to this family. Ivanka is facing prison because of her silence." Eric answered simply, "I'll talk to her." The defendant fired back, "Talk won't fix this. She needs to know there are penalties. I have prosecuted organized crime syndicates where this exact type of family pressure was presented as evidence of obstruction of justice. This is a pattern. Instant explosive rage, followed by the mobilization of other family members to pressure a witness. In the legal world, we call this awareness of guilt. An innocent man generally reacts with confusion or sadness. A guilty man responds with threats and demands for loyalty. Evidence item 3, a post on Truth Social. At 11:27 a.m., the defendant released a message to the world. It was live for exactly 17 minutes before being deleted at 11:44 a.m., but on the computer, 17 minutes is an eternity. We captured and saved the screenshots. The post read, "Disloyal wives who put lawyers before family will learn what real consequences mean. Some people value their own skin over their children." Sad. He deleted it, but the damage is permanent. We have the proof. This ties the private rage to a public threat. Why does this matter? Because when someone responds with this level of volatility, when they threaten consequences rather than showing concern for the legal process, it suggests they know exactly what the witness is hiding. If Melania's evidence was irrelevant, why the explosion? Why the pressure effort on Eric? Why the public threat? I have made RICO cases against mob bosses who turned on their own blood when they cooperated. I know this smell. It is the scent of fear. I want to hear from you in the comments area. When you look at this reaction, the smashed phone, the text to the son, the deleted threat, do you see a frustrated father or do you see awareness of guilt? I read every viewpoint. Now, let's get into the cold, hard numbers. We need to break down the prison time Ivanka is actually facing, because the math shows why Melania's silence is so destructive. Ivanka is charged with 3 counts of bank fraud under federal law. The maximum penalty is potentially 30 years per count. However, federal courts do not simply throw the maximum at defendants. They utilize the federal sentencing guidelines, a rigid mathematical formula that accounts for the severity of the crime, the criminal past of the defendant, and whether they have accepted responsibility. For bank fraud involving loan applications exceeding $10 million performed with sophisticated means, a legal term for complex cover-ups, the guideline range sits between 8 to 12 years per count. While Ivanka faces 3 counts, sentences for related conduct typically run concurrently, meaning at the same time. So truly, for the bank fraud alone, she is looking at 8 to 12 years. Then you add the 2 counts of tax theft. The standards for the dollar amounts involved here suggest 2 to 4 years per count, again, likely concurrent. Finally, the single count of agreement to commit fraud. That gives a guideline range of 1 to 3 years. Federal judges will often stack these areas when the crimes, while related, represent separate acts of lawbreaking. You have the bank fraud plus the tax fraud plus the plot. When you do the math, the total dose range is 11 to 19 years. That is the standard. That is the starting point without any help. This is where Melania's testimony was important. Under the federal rules, there is a mechanism called substantial assistance. When a defendant's family member gives crucial aid to the prosecution, a judge has the discretion to grant a downward departure. Typically, this results in a decrease of 20 to 40% of the sentence. Had Melania cooperated, that 11 to 19-year range could have dropped to approximately 6 to 10 years. Because Melania refused, my sentencing memorandum to the judge will now suggest the high end of the guidelines. I will be looking for 16 to 19 years. Why? Because there is no acceptance of duty. There is no teamwork. There are no mitigating factors to soften the blow. If she had help, I could have justified asking for the low end, 6 to 8 years. And remember, federal judges adhere to these suggestions about 85% of the time. There is no parole in the government system. If Ivanka is sentenced to 16 years, she will physically serve a minimum of 13.6 years behind walls. Let's look out. We need to look at the broader picture, because this isn't just about Ivanka. She is the third Trump family member I have charged in connection with Trump Organization crimes. This reveals the anatomy of how criminal enterprises work. When authorities charge a father, a son, and a daughter in related schemes, critics call it a vendetta. We call it following the signs of coordinated activity. The defendant himself is already charged with 34 counts of business fraud and obstruction connected to the hush money concealment. The structure of that crime was similar. Use the organization's resources to commit the act, then use false documents to hide it. Donald Trump Jr. has been charged with 2 counts of tax evasion and 1 count of money laundering linked to shell companies hiding foreign income. The approach was the same. Overseas accounts, hiding the true owner, lying to the ears, and now Ivanka. Bank fraud, tax fraud, conspiracy, different banks, different tax years, but the exact same blueprint, falsifying papers using offshore havens, leveraging the Trump Organization infrastructure to facilitate the crime, and importantly, coordinating with other family members. In a courtroom, we describe this as an ongoing criminal enterprise. Outside the hall, it means that when a family runs a business and multiple members commit the same types of financial crimes using that business as a tool, it stops being about individual bad apples. It becomes a habit of organizational criminality. I prosecuted the Gotti family in New York in the 90s for RICO crimes. The crimes were violent, extortion, racketeering, murder, but the family system was the same. The father, the kids, the criminal enterprise masquerading as a respectable business. I know the organizational hierarchy. This study has been a marathon because financial crimes demand absolute precision. We have tracked money through 17 different countries. We have deposed 134 witnesses. We have analyzed 4.7 million pages of documents, emails, ledgers, company filings. And this is why Melania's refusal is the sticking pin. She is the only family member who had first-hand sight across all 3 cases. She was in the room for the defendants' meetings. She had access to the financial info regarding Don Jr.'s offshore entities. And she witnessed the exact acts Ivanka is charged with. Her evidence could have been the thread that tied all 3 cases into one undeniable narrative of a family business built on systemic fraud. She chose to cut that thread. So what happens next? The schedule is now locked. Melania's choice is final. The clock is going down. The hearing date is set for June 9th, 2026. That is exactly 124 days from this moment. There will be no more delays. Jury selection begins on that morning. Here is the road plan for the next 4 months. March 15th is the date for final pre-trial motions. April 7th, we hold evidentiary meetings to argue over disputed exhibits. May 1st, the witness list is set in stone. June the 2nd, the jury questionnaires are sent out, and on June 9th, the process starts. Selection will take about 3 days. Opening statements will start on June 12th. I will give the prosecution's case for approximately 2 weeks, running from June 12th through the 26th. We will bring the papers. We will bring the financial pros. We will bring the accountant who sat in that meeting in May 2019. We will bring everything except Melania. The defense will make their case on June 30th. Closing argument should happen around July 14th. And then the jury goes into the deliberation room. Because of Melania's refusal, I will be relying 100% on the documentary proof, and frankly, that proof is mountainous. We have the bank records showing the numbers were lies. We have the email chains proving the orders were given. We have the text messages revealing the cover-up. We have the cooperating witnesses from inside the bank and the accounting company. I have spent 30 years pursuing bank fraud. Juries understand papers. A piece of paper does not have a purpose. It does not have a memory loss. It does not lie to protect its father. Wire transfer records showing $47 million moving based on a fake valuation speak a global language. The system works when we let the facts lead the way. A grand jury looked at this information and voted to indict. A judge looked at the Constitution and set a hearing date. Now we just have to watch the tools work. No one is above the law. Not the patriarch, not the boys, and not the daughter. That isn't a party slogan. That is the foundational concept of every case file on my desk. The trial starts in 124 days. I will be here to help you through every motion, every objection, and every piece of evidence as it is entered into the record. If you want to watch this trial as it happens, make sure you are subscribed. And I want to ask you one final question. Leave your answer in the comments. Do you think the documentary evidence alone is enough to secure a conviction without Melania's testimony? I want to know where the public stands on this. We just dissected the legal danger facing Ivanka, but her trial pales in comparison to the reality that just crashed down on her father. The judge read his sentence this morning. Maximum security, 23 years. I break down exactly what happened inside that courtroom in this video right here. Click there, and I'll see you in a few.